Welcome to Spoken Injustice, where we put the criminal justice system in the dock. If you recall in our opening note, we mentioned that the Law Commission is currently looking into a wide-ranging reform on criminal appeals in England and Wales. You can find that video linked in the description below. In that video, we anticipated that the pre-consultation stage was underway and that the Law Commission's consultation papers were awaited by the end of the year. Well, that time has come earlier than anticipated. The Law Commission has now published an issues paper and views from the public and those with experience of the appeals system are now sought. Responses are to be submitted by the 31st of October 2023. However, perhaps it is worth noting that the Law Commission does not consider this the final consultation. If we look at page 4 of the summary paper, it's stated, we intend to publish a consultation paper in 2024, which will contain more detailed consideration of the law, including some technical matters not covered in this paper, and will contain provisional proposals for reform. There will be a further consultation on that paper before we publish a report containing final recommendations. So, though this consultation seems to be ahead of time, it seems that the original time schedule for the full report remains unchanged, if not slightly delayed. Before looking at the issues paper, perhaps it is useful to remind ourselves of a few brief facts about the Law Commission, for those who are not too familiar with the subject. The Law Commission Act 1965, at Section 1, states, for the purpose of promoting the reform of the law of England and Wales, there shall be constituted in accordance with this section a body of commissioners to be known as the Law Commission, consisting of a chairman and 4 other commissioners appointed by the Lord Chancellor. On the 29th of June 2023, an announcement was made that Sir Peter Fraser had been appointed as the new chair of the Law Commission of England and Wales. He will take up the post on the 1st of December 2023, and his predecessor is Sir Nicholas Green. The Law Commission is a statutory body independent from the government. It means that it is independent from government's policy. Its aims are to ensure that the law is as fair, modern, simple, and as cost-effective as possible, to conduct research and consultations in order to make systematic recommendations for consideration by Parliament, and to codify the law, eliminate anomalies, repeal obsolete and unnecessary enactments, and reduce the number of separate statutes. The phases of a typical law reform project include the initiation phase, when the remit of the project is defined, the pre-consultation stage, when the Law Commission undertakes a study of the area of law and identifies issues within it, the consultation stage, when a consultation paper is issued. This gives details of any issues, concerns, and arguments in relation to that area of law and is circulated in the media to invite views and feedback from any interested members of the public. Then there is the policy development stage. In this stage is the stage when responses from the public are analysed and the study is further refined and developed. And finally, there is the reporting phase, in which a report is provided to the Lord Chancellor, giving their final recent recommendations. Perhaps the most important fact to have regard to in relation to the Law Commission is that at the end of the consultation period of any relevant project, the Law Commission will provide its recommendations. These are exactly what it is said on the tin, i.e. recommendations. They are not binding, and it is ultimately up to the Parliament to enact any proposed reform. In other words, they do not become law unless implemented by the Parliament. I hope you have found this information useful. Now, before turning into our analysis of the Law Commission issues paper in this particular project of criminal appeals, here are my usual reminders. We noticed that whilst we've had almost 1,000 views in the last 28 days, for which we are extremely grateful, the number of subscribers has not mirrored the number of views. If you find this channel useful and want to be kept updated on issues that concern our criminal justice system, then please subscribe if you have not done so already. Also, like our videos and leave your comments below. These actions not only are important to us, as it is your way to let us know your views and any suggestions you may have in relation of the content of this channel, but they also directly influence the reach and growth of the channel. Thank you. So back to the criminal appeals reform, let's look first at the Law Commission's announcement of the issues paper, which came out on the 26th of July 2023. First, we can see the context of the consultation. As is stated, the Law Commission is reviewing the law to ensure the courts have powers that enable the effective, efficient, and appropriate resolutions of appeals. In response to the argument put forward by several bodies, including the Justice Select Committee and the Westminster Commission on Miscarriages of Justice, that there is a need for reform. Scrolling down to the bottom, you can see that commenting on the issues paper, Professor Penny Lewis, the Commissioner for the Criminal Law Area, qualifies further the context of the review. And she says, in our comprehensive review, we will consider proposals for reform that will ensure the appeals process provides a robust safeguards against wrongful convictions and instills confidence in the criminal justice system. This focus is indeed welcomed. Now, going onto the main Law Commission page, you can see something that you should find by now familiar, as it has the same appearance as the page examined in relation to the issues papers for the consultation on the reform on sexual offences trials. If you missed that video, you can find it linked in the description below. So in the same style and format, there are two consultations paper. One in summary, containing 10 questions which the Law Commission is seeking views on, and a full consultation paper containing 18 questions which the Law Commission is also seeking views on. Secondly, it zooms into some of the areas the Law Commission is looking into, particularly the tests applied by the Court of Appeal and the Criminal Cases Review Commission, and laws governing post-trial retention and disclosure of evidence. We have covered all these concerns and provided examples throughout our videos. Again, this focus is indeed welcomed. The summary consultation paper does an excellent job in highlighting and clearly summarising how the appeals system for decisions reached at magistrates' court level currently works. The system offers 3 routes, where a defendant has been convicted and sentenced by the magistrate's court. Appeals against both conviction and or sentence are dealt with by the Crown Court. These appeals, if timely lodged, do not require permission or leave from the Crown Court, and operate by way of rehearing, i.e. all facts are re-examined. The second route, magistrates' court's convictions, sentences and acquittals can also be appealed to the High Court by way of case stated, on the grounds that it was A, wrong in law, or B, in excess of the court's jurisdiction. And finally, magistrates' court decisions may also be challenged by both the defendant and the prosecution by way of judicial review in the High Court on the ground that it was A, unlawful or irrational, or B, there has been procedural impropriety. The Law Commission's question is whether there is a need to reform the processes by which the magistrates' court in criminal cases can be appealed or otherwise reviewed. The process seems, in our opinion, comprehensive and all-inclusive. Though perhaps there is some degree of overlapping within the 3 routes, it seems to afford ample opportunities to both prosecution and defence to seek redress on various grounds. So in our opinion, really, there is no need for reform. Conversely, the same clarity is not afforded to appeals against convictions on indictment obtained at Crown Court level. This is because the process is in fact both complex and confusing. Firstly, appeals to the Court of Appeal, unlike those to the Crown Court, require permission from the Court of Appeal. They also do not operate by way of rehearing. Appeals can only be brought on one ground, that is, that the conviction is unsafe. Whilst the consultation paper states that unsafe is not limited to situations where the person is factually innocent, but also includes situations where the evidence was not sufficient for a properly directed jury to be sure that the appellant committed the offence, the appellant did not receive a fair trial, the prosecution amounted to an abuse of process. In reality, innocence or sufficiency of evidence are not factors taken into account by the Court of Appeal. Whilst this may have been the intention of the legislator when the Criminal Appeal Act 1968 was amended in 1995, the Court of Appeal's approach has been and is that it will consider a conviction unsafe only whether there has been a serious unfairness in the conduct of the trial or a significant legal misdirection. As per the concerns in relation to jury trials, the consultation paper explains this very clearly, particularly the fact that juries do not give reasons for their verdicts and their deliberations are secret, which have direct consequences on the ability to appeal a conviction, and the fact that the Court of Appeal is very reluctant to quash a conviction arrived by a properly directed jury. We have highlighted all these concerns in our videos on criminal appeals and on jury trials, which you can find linked in the description below. The consultation papers also refer to the issue of the admissibility of fresh evidence. Currently, the court may admit fresh evidence if they think it necessary or expedient in the interests of justice. On the basis of certain criteria, for example, that the new evidence appears capable of belief, or that there is a reasonable explanation for the failure to adduce it in the Crown Court proceedings. Under the section Remedies Following the Quashing of a Conviction, the consultation then refers to the painful issue of compensation or lack of it in most cases in which the conviction is quashed. It states compensation will only be payable if the person's conviction was quashed or they receive a pardon because newly discovered evidence shows that there has been a miscarriage of justice. Compensation will not be payable if the conviction was quashed in an in-time appeal, and will only be payable where it can be shown beyond reasonable doubt that the person did not commit the offence. Again, we have covered these issues in several of our videos, which you can also find in the description below. The Law Commission asks, A, whether there is evidence that the Court of Appeal's approach to assessing the safety of a conviction hinders the correction of miscarriages of justice. And 2, whether the options and remedies available following the quashing of a conviction by the Court of Appeal are adequate and appropriate. In light of the above, and in light of the compelling arguments we have illustrated in several of our previous videos, the answer seems clear and compelling. The answer to the first question is yes, there is evidence that the current approach hinders greatly the correction of miscarriages of justice. And the answer to the second question, no, the remedies available are neither adequate nor appropriate. Let's now turn into the Law Commission question in relation to the Criminal Cases Review Commission, or CCRC for short, which is the body in charge of investigating miscarriages of justice. First, the Law Commission explains that the CCRC may only refer a case for an appeal where there is a real possibility that the court will not uphold the conviction or sentence because of a new argument or evidence that has not been raised in the original proceedings or on appeal, and that the conviction or sentence has previously been appealed against. unless there are exceptional circumstances justifying a referral. In the summary paper, the issue in relation to the real possibility test is brilliantly captured by the Law Commission by way of reporting verbatim the position of the Westminster Commission on Miscarriages of Justice, which we not only highlighted, but wholeheartedly adopted in our video on criminal appeals. Namely, that the test encourages the CCRC to be too deferential to the Court of Appeal and to seek the second-guessing what the court might decide, rather than reaching an independent judgment of whether there may have been a miscarriage of justice. The Law Commission's question on this point is there evidence that the referral test used by the CCRC when considering whether to refer an appeal hinders the correction of miscarriages of justice? If so, are there alternative tests that would better enable the correction of miscarriages of justice? In our view, in light of what we have discussed here and in previous videos, the answer to the first question should undoubtedly be yes, there is plenty of evidence that the current test hinders the correction of miscarriages of justice. The recent case of Mr. Markinson compellingly demonstrates so. As per the second question, in relation to any alternative tests, we believe that the CCRC should look at each application on the merit, conduct the relevant investigations, and if at the conclusion of its investigation believes that it is in the interest of justice to refer a case to the Court of Appeal, then it should do so, leaving the Court of Appeal to decide whether, on the basis of the new investigation, the conviction should be overturned or the sentence reduced. The remaining areas explored by the consultation papers are areas that we have not yet explored, and therefore we defer their analysis to a later date. I hope you have found this video interesting, and if so, like it and let us know your views in the comments below. Also, consider subscribing to help us grow this channel so that we can continue bringing you the latest news affecting and informing our criminal justice system. And of course, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. We look forward to usher you as we sit and rise in this unique trial.